5 seconds to go. Start. In the decision in State of MP versus Awadh Kishore Gupta and others, this court held that the High Court could not embark upon an inquiry as to whether the evidence is reliable or not, as that would be the function of the trial court. In Dr. Monica Kumar and another versus State of Uttar Pradesh and others, this court held that the inherent power under Section 482 CRPC should not be exercised to stifle a legitimate prosecution. A two-judge bench of this court held thus: plenitude of the power under Section 482 CRPC by itself makes it obligatory for the High Court to exercise the same with utmost care and caution. The width and the nature of the power itself demands that its exercise is sparing, and only in cases where the High Court is, for reasons to be recorded, of the clear view that continuance of the prosecution would be nothing but an abuse of the process of law. It is neither necessary nor proper for us to enumerate the situations in which the exercise of power under Section 482 may be justified. All that we need to say is that the exercise of power must be for securing the ends of justice, and only in cases where refusal to exercise that power may result in the abuse of the process of law. Having made such a short survey on authorities on the exercise of power under Section 482 CRPC as above, we will now refer to the object and purposes of the POCSO Act. Article 15 of the Constitution, inter alia, confers powers upon the state to make special provisions for children, and Article 39F provides not only that the state shall direct its policy towards securing that the children are given opportunities to develop in a healthy manner and in conditions of freedom and dignity, but also to ensure that their childhood and youth are protected against exploitation and against moral and material abandonment. Recognizing the constitutional obligation and keeping in view the fundamental concept under Article 15 of the Constitution, and also realizing that sexual offences against children are not adequately addressed by the existing laws, POCSO Act was enacted. The provisions thereunder would reveal that it also aims to ensure that such offenders are not spared and should be properly booked. To achieve the avowed purpose, a legal obligation for reporting of offence under the POCSO Act is cast upon on a person to inform the relevant authorities specified thereunder when he/she has knowledge that an offence under the Act had been committed. Such obligation is also bestowed on person who has apprehension that an offence under this Act is likely to be committed. Besides casting such a legal obligation under Section 19, the legislature thought it expedient to make failure to discharge the obligation thereunder as punishable under Section 21 thereof. True that under Section 21(1), failure to report the commission of an offence under subsection 1 of Section 19 or Section 20, or failure to report such offence under subsection 2 of Section 19 has been made punishable with imprisonment of either description, which may extend to 6 months, or with fine, or with both. Subsection 2 of Section 21 provides that any person who, being in charge of any company or an institution, by whatever name called, who fails to report the commission of an offence under subsection 1 of Section 19 in respect of a subordinate under his control, shall be punishable with imprisonment with a term which may extend to 1 year, or with fine. Certainly, such provisions are included in with a view to ensure strict compliance of the provisions under the POCSO Act, and thereby to ensure that the tender age of children is not being abused and their childhood and youth is protected against exploitation. Looking at the penal provisions referred above, making failure to discharge the obligation under section 19(1) punishable only with imprisonment for a short duration with 6 months, one may think that it is not an offence to be taken seriously. However, according to us, that by itself is not the test of seriousness or otherwise of an offence of failure to discharge the legal obligation under section 19, punishable under section 21 of POCSO Act. We are fortified in our view by the decisions of a 3-judge bench of this court in Vijay Madan Lal Chaudhary and others versus Union of India and others. A 2-judge bench of this court in paragraph 77.5 and 77.6 issued certain directions for due compliance, and they read thus: if hospitals, whether government or privately owned, or medical institutions where children are being treated come to know that children admitted are subjected to sexual abuse, the same will immediately be reported to the nearest Juvenile Justice Board SJPU, and the Juvenile Justice Board, in consultation with SJPU, should take appropriate steps in accordance with the law safeguarding the interest of the child. Stop.